Hello, my name is Crystal Dahl, and I'm the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar. For those of you that are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 250 markets around the world since 1990. Meritas capability webinars are regularly presented by Meritas members. Before we get started, I just wanted to go over a few housekeeping items. Meritas offers the ability to listen to our webinars through your computer speakers, but if at any time you have difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience technical difficulties on the phone, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the question pane found on the GoToWebinar module. You may need to click on the gray bar that says questions to expand the section. The presenters plan to answer questions at the end of the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of this webinar, as well as the presenter's contact details. Please feel free to share the webinar recording with anybody you might who might find it of interest. With that, Clarissa, are you ready to get started?
Yeah, thank you. Thank you. Thank you everyone for coming here and for staying with us here. And we're going to talk about privacy concerns during and after the pandemic. I'm here with Robert Lenz. He's the partner of Howard Kennedy in London. Thank you, Robert. We are also with Bartosz. He's from Poland, and he's a partner also. He's a specialist also in privacy. And well, thank you all. We also will have a guest here. His name is Fred Taylor, and he will be with us. He will participate in this meeting and this webinar. And this is a very special webinar for me because we're in Brazil. We're in the middle of a very bad crisis because of the pandemic. After Europe has already passed through it, not already, but is passing through it. In Brazil, we are in the middle of it, and we have not achieved the peak of it. So we are hearing from you also about the privacy concerns, which in Brazil, we have a problem because our first regulation on data protection has not yet entered into force. So we are still waiting for the definition of its date. And that brought a lot of problems here in Brazil, but also a good thing. In beginning of May, the Supreme Court in Brazil rendered a decision in a case that was very similar to the census case in Germany in 1983. So although we do not have a regulation on data protection here, and now right now at this time, we have had this great decision by which the Supreme Court considered that the personal data must be protected and guaranteed as a fundamental right. So as you can see, in Brazil, this is a pretty new issue, and it's getting stronger, and its importance is increasing, especially due to the pandemic. So this conversation will bring to Brazilians also a very important view from the European perspective. So I thank you again. And please, let's start with the presentation from Robert and Bartos. Thank you.
Thanks, Larissa. Yeah, here in the UK, we've also had it pretty bad. So we've been in lockdown since March. We've had 280,000 confirmed cases of the virus, 50,000 deaths, which puts us, I think, just second in the world, just behind the USA. But things are starting to get better. The numbers are coming down. As you say, we are past the peak here. And restrictions in the lockdown are starting to ease. So we have different rules in the different parts of the UK. But in England, some kids have started to go back to school, and non-essential shops will open on the 15th of June, which is soon. So yeah, hopefully life will return to normal soon. And for that to happen, there are going to be some things that will need to be put in place, like contact tracing and apps, and these are the kind of things that we'll be discussing on the call today. We thought that we would sort of set the scene from the European perspective by talking a little bit about the GDPR, the General Data Protection Regulation, which is our main data protection law. I'm sure that most people on this call will have heard of it, at least. It turned 2 years old last week, so it's pretty famous for a 2-year-old. But it introduced a whole new regime for the processing of personal data, and enormous potential fines if you get it wrong. The fines are up to a maximum of 20 million euros, or 4% of your global annual turnover. So that's pretty huge. So everything that we discuss about the privacy implications has GDPR as a backdrop and compliance with GDPR. We're not going to sort of take you through the whole of the GDPR in detail, because that would be a couple of hours in itself, and probably is unnecessary for many people on this call. But we thought it might be useful if we just explained a couple of the key terms that we'll be using today, and the principles enshrined in the GDPR. So if I can see if I can advance the slides. I could do it just a minute ago.
When waiting for you, Robert, oh yeah, we are okay. We are okay. Okay,
Yeah,
basically, I wanted to present short report from Poland. I think we are in the most relaxed position in terms of Northern Europe, Northern Eastern Europe, somehow on this relatively safe side. So gathering the statistics, we have like a little bit more than 1,000 deaths and 25,000 cases identified. So not so dramatically affected, even though our lockdown started around 85 days ago, and now it is kind of a soft return, I would say, what we are experiencing. Even though, as you may see, I'm still in my home. We have home office for last 85 days, I believe. So more or less, brief report on the pandemia from Poland.
And I guess if I may as well add from the United States perspective where we are with the COVID crisis, and of course I'll get into how it relates to privacy later, but I guess to just introduce myself, I again am Fred Taylor. I'm a partner with the Meritas firm located in San Diego, California. The firm is Procopio, Corey, Hargraves, and Savage, and I chair the Privacy and Data Security Practice Group. And from the United States, I know that I'm not exactly sure how much news is covered internationally for the United States, but we have clearly had the largest COVID outbreak and problem. We're, I think, currently at over 106,000 deaths, which is, I think, by far the most of any place in the world. And sort of related to how we have sort of dealt with the crisis is a little bit similar to how the data protection laws and a lot of laws in the United States kind of operate. It's a very disparate federal system where you have 50 different states, which in turn you will get 50 different approaches to the COVID crisis. Here in California, we were one of the earliest states to implement stay-at-home orders and quarantines. We are just in California going into one of 4 stages in terms of returning back to work. As you can see, I'm still home. My small daughter is still homeschooling and trying to get access to her schoolwork from here. We anticipate that hopefully things will be relatively back to normal by the fall, by September. But it'll be somewhat of a slow process. But again, it's more of a state by state process in terms of dealing with handling the COVID crisis. And we'll get into more of what California is doing and what the United States is doing in terms of privacy and data protection issues that have arisen from the COVID crisis.
Thank you. Yeah. Yeah, people also don't realize how fragmented we are with our different countries in the UK. It's like the States in that respect. We have the law, the data protection law is actually the same throughout the UK, but each country can set their own rules for health and safety in a pandemic. So in Scotland, you can meet with up to 8 people, and in England, it's a maximum of 6. So if you're visiting the grandparents and you have 4 kids, then you probably have to leave one in the car, which is kind of ridiculous. Yes.
If I may, sorry, it is not very natural way for us to have the discussion. So for our dear audience, what I wanted to say, it's also one of the conclusions for me, and I don't want to have conclusion after 10 minutes of our webinar, but basically one of the conclusions is also the EU is pretty fragmented. Even though GDPR's role was to have it unified as much as possible, in the end, COVID situation, and maybe this is also the lesson for Brazil and Clarissa and your team, that basically we ended up in a pretty fragmented reality. And actually, when we will move on with our presentation, our discussion, I think we will have examples of those fragmentation, which is deeper and deeper.
We'll see how that works. Yeah. So just to explain some of the concepts then, when we talk about personal data, as it says on the screen, it's really any information relating to a person, a living person who is identified or can be identified by combining that data with something else. So if you remove their name, it can still be personal data because you can still work out who it is, perhaps. There's a definition on the screen of data concerning health, which would cover someone's COVID status. Are they well? Are they sick? Do they have antibodies to protect themselves? And the reason why that definition is there is that it's very important because it forms part of a subset of data in the GDPR known as special category data. And there are rules about processing special category data that are more restrictive than the normal rules. So often when we talk about personal data implications of dealing with things in the pandemic, we're talking about processing special category data. And when I talk about processing, processing is also very widely defined. It means doing anything you can think of with the data, pretty much. Even just having a copy of it on your computer, storing it is processing. So I shall attempt to advance the slide again.
And if I may on those, just maybe 2 remarks. I would say GDPR typically for that kind of regulations in Europe is very non-precise, I would say, plenty of gray zones, appropriate measures, proportional modes, data processing covering inter aliam, and then entire list which is not exhaustive. So this is absolutely typical, and we have to struggle as lawyers all the time with understanding, and that's why we also share information among Meritas member firms, what national data protection authorities are doing and how they interpret the regulations, because regulations are full of those places for interpretation, I would say. We have, unlike Brazil, we were relatively lucky in Poland, because even before we joined the EU, we had the Data Protection Act 1997. 1997, that's right, yeah. Therefore, the experience is relatively long, and it was also very broad, very vague, very unclear, leaving lots of space for interpretation, for court rulings, etc., etc. So I think it is quite typical that we will see plenty of names, terms, definitions as those that Robert just presents on the screen.
Yeah, those ones I had on the screen are definitions, but as Bartosz says, there are plenty of terms in the GDPR which are not defined. Things like large-scale processing. You know, what's large-scale? There's guidance on these things, but you know, we don't know how a court would interpret it until it comes before a court, and the GDPR is only 2 years old. So there is lots of grey there. What's quite clear is these principles which underpin the GDPR. So they're on the screen there, and they're pretty self-explanatory. Fairness, lawfulness, and transparency should really be in a hexagon like everything else, but that's the first principle. And then you go around that little chart to see that you have to only process for limited purposes. You have to make sure that the data that you process is accurate and up to date. You have to ensure that you're only processing the minimum necessary data, that you keep things confidential. Security is very important. Storage limitation is to do with retention. You can't keep data forever without a reason for that. And what's new in GDPR compared to the legislation it replaced is this accountability principle. That is really the sort of heart, the philosophical heart of the GDPR. Because what it means is that it's not enough to be doing the right thing. You have to demonstrate that you thought about it. You didn't just accidentally reach the right result. You went through a process. You documented it. There's strong record-keeping requirements in the GDPR. You have to think about the concept of privacy by design and by default, meaning that whenever you decide to do something new, like reading people's temperatures, you have to consider the privacy implications of that, and you have to design it in such a way that the privacy implications are minimized. You have to really bake it into everything that you do. So,
and again, if I may, basically, as you could see, there is plenty of words like limitation, minimization, storage limitation, purpose limitation. So GDPR theoretically is all about limiting, meaning you have to delete the data as soon as you don't need it or to anonymize it. You have to keep as much data or as little data as is absolutely sufficient for achieving defined goals, etc., etc. And now we are moving slowly this way into the COVID situation, where we or the government or the health authorities are trying or maybe trying to extend those limitations, saying, oh, we also need to know exactly where Robert is located. Maybe Robert is next to Bartosz, and maybe therefore there is health exposure existing. So this is this challenge. Again, philosophically, the challenge we are heading to, and the governments globally, governments worldwide are heading to, and lawmakers, how to balance those values, how to keep it as little as possible, and still to achieve absolutely new goals that no one considered while drafting GDPR.
Yeah. So when you process personal data, you have to have a legal basis for doing it, and we're not going to go through those. What we are going to just touch upon here is the additional legal basis that you need when you process this special category of personal data, including health data. So you have to have an ordinary legal basis, which could be your legitimate interests or consent of the individual. There's a list of those. And then there's this more restrictive list for special category data. I think there's some background noise. Does somebody have some noise there that they need to mute their mic? Crystal, perhaps?
I'm sorry, what was that, Robert?
Sorry, I think you need to mute your microphone. There's some background noise being broadcast.
So that wasn't me.
It wasn't you. Oh, okay. I'll carry on. So I was just saying there are these special conditions that you have to fulfill. You have to be able to hit at least one of them. Processing health data is banned unless you can do that. There's actually 10 of them in the GDPR, and we put 6 on these 2 slides because the others aren't really relevant here. And these 2 slides are the last 2 GDPR slides, you'll be pleased to hear. So I'm not going to read out these things, but just going to highlight a few things. Firstly, you'll see that explicit consent is a condition that you can use to process health data, which sounds good, but consent can be withdrawn, and that can cause problems for the data controller. And more importantly, there are big problems in relying on consent when you're doing things with your employees, like if you want to take their temperatures or you want to share information about employees, because the consent from employees is often not considered true consent because of the imbalance of power in the relationship between the employee and the employer. It's not considered to be freely given consent, and so it doesn't count. You also see that the third one there says that you can process special category data to protect the vital interests of a data subject, which just means an individual, which also sounds good, but it only applies when that individual is incapable of giving consent. So we're really talking about emergency situations. You know, you need to perform an operation on somebody and they can't consent because they're unconscious. So that's not going to be of much use in most ordinary circumstances. A lot of employers in this country anyway would be looking at the middle one there, which allows you to process health data if you're doing so to exercise your obligations under employment law. But what you'll notice about that and the ones on the subsequent slide is that it relates to a law outside of the GDPR. It relates to an employment law in an individual member state. And that is what Bartosz is saying before about how the GDPR is supposed to provide one regulation that applies throughout the EU, which it does. But when you look at when you get into the granular detail like this, you realize that you need to know the national law as well, and the national law can be different in different countries. So that's one of the reasons why we have 2 European lawyers on this conference. But really, you would need like 28 of us, and that's actually one of the advantages that Meritas has as a network. There are experts in every jurisdiction, and so before doing this call, Bartosz and I contacted some of our colleagues in other European countries and asked them some questions. And you'll see later on we've put some highlights from their answers on the screen.
If I may, Robert, because before you flip, on point number 2, we had quite interesting interaction, because actually I prepared this very slide and you said, oh, come on, point number 2 is missing and it is vital in the UK. And I was actually relatively surprised, because I don't feel it is so vital or so widely used here in Poland, even though we still have the same GDPR regime. So this is also interesting illustration of what we discussed earlier, that basically it is pretty fragmented and getting more and more fragmented. On number 3, also interesting, because indeed incapable of giving consent, it is a very important and quite forgotten phrase in this GDPR article, while this provision is quite popular because it refers to recital 46 of GDPR, and this is the only recital or the only article of GDPR referring to epidemics. Basically, it says that GDPR can be used, or data can be used, can be helpful in monitoring epidemics and their spread. However, as you said, it is quite an emergency situation. It refers to emergency situation, coma, hospital situations, not a normal life situations.
Yeah, thanks. I'm trying to advance the slide. I think there's some lag because I'm advancing the slides on a computer in Minneapolis and I'm in London. Okay, it's worked. So yeah, so these are the other few that we thought were applicable to kind of COVID-19 processing. There's a substantial public interest one, which again relies on national law. So you have to look to see if you have a basis in your local law. There's one about assessing the working capacity of employees, and one there about public interest in the area of public health, including protecting against serious cross-border threats to health, which all sounds very relevant. But actually, that one, when you refer back to the recitals that Bartosz mentioned, on this one, there's a recital that says that this one can't be used by employers. So it's really for medical care providers, and several of these actually can only be carried out under the responsibility of a professional who has obligations of confidentiality, so a doctor or somebody.
Again, if I may, interesting statistics from my side, and very, very basic. Basically, 4 out of these 6 GDPR regulations refer to national laws. Therefore, indeed, in most popular data processing basis, you need to check what national law says, whether it is Polish, British, English, French, so on and so forth. Therefore, we end up with more than 25 national regulations. So this is similar, Fred, I would say, to what you said at the very beginning to the United States. Maybe not 50 plus, but still we have like almost 30 different national laws you need to consult.
Yeah. Also, four out of 6 of these start with the phrase "processing is necessary," which is interesting because that's another one of those phrases that isn't really defined. What does necessary mean? The guidance actually is that it doesn't mean that it's the only way of achieving it, but it does mean that it has to be something more than merely useful, and it has to be also reasonable and proportionate. I think that was all I wanted to say on these slides. So our next slide just puts up some of the topics we thought that we could chat around. Where should we start, Clarissa?
If I could, I'm gonna add something here to start these considerations. What I think is that last week we've been seeing what have been happening in the United States. Fred, if you could help us here with this fact, because of the Black Lives Matter in Minneapolis, I'm sorry, Minnesota. We've seen that the contact tracing technology that has been used for the pandemic might have been used by the police for monitoring the protesters. So this, again, because of the pandemic, we've seen what have always happened in society ever since the beginning of it: technology against privacy. So in 1888, when the first camera was developed by Kodak, the first manual camera that you could take it anywhere. So it was that in 1888 it was developed, and then the journalists, everyone could take pictures from everyone in many places. So that led to the doctrine of the first privacy doctrine as something that could go out of your home. So your privacy was not limited to your property anymore. So as you know, Brandeis, Warren and Brandeis, and the doctrine of that they developed. And then ever since, the technology against privacy has always been an issue. So now it's the same thing. So we see the contact tracing apps, we see the monitoring through geolocation by the tech companies, by the telephone companies, and all of that leads to what we're facing now.
Yeah, if I can add some perspective.
Yeah, please, Brett. Yeah.
Okay. If I can add some perspective to that from the United States, and again, it's a couple things to emphasize in terms of privacy and how it's dealt with in the United States. In terms of privacy and data protection, there is no overarching law in the United States similar to GDPR here. It is more so a collection of each state's laws. Now, there is the California Consumer Privacy Act, and that is a law that's here in California, but because of its broad implication, because California is such a large state, it really does have sort of downstream effects to the other states. But in terms of the, and I can get into some of the aspects of CCPA a little bit later, but in terms of these issues related to COVID, in terms of contact tracing and privacy concerns. You will have the concern that Clarissa just mentioned that the police will not be able to use that data to, they should not use that data to trace individuals, right? They may use it for just to see where large groups are going under the protest. They can be able to do that to show where there's a concentration of people, and that way they can use that data to go there to make sure that things are under control. But they really can't use individualized data from a person's cell phones in order to do individual contact tracing. So, and the United States Constitution, along with some Supreme Court authority, has made it pretty clear that there has to be a warrant or some other exigent circumstance in order to do sort of direct tracing of individuals. But as you can see, in the US and in society in general, there are so many cameras, just kind of mentioning the initial photographs, and there's so many the public ways that you can get information about where people have been, where they're going, that a lot of the contact tracing really is public data that's just available because you are out and about on the street. So those are some very sort of overarching concerns that are here in the United States.
Great. Thank you, Fred. Yeah, another thing that as in the GDPR, the CCPA, or whatever regulation we can talk about as regards to privacy, the anonymization of data is always something that it's close to impossible, right? So if we say that your geolocation is aggregated or not, or whatever, you do not access the individual data, maybe you're saying that you cannot individualize at that time, but further on you can do that. So you will be able to individualize and achieve the personal, the person to which the data refers to. So it's cool. So
if you're tracking someone by relation to their location or their device ID from their phone, then that, from our perspective, that's personal data, and you have to respect the rules if you want to do that, because we are very worried about this purpose creep, the function creep of it, that you collect the data for one reason and then suddenly it's used for something else, like to control a protest, which has nothing to do with the pandemic. It is concerning.
Yeah, especially when you can get to a special category of data by tracing steps regarding the people's going to hospitals or whatever. We are talking about special category here, right? Not only personal data.
Do the COVID-19 apps in your 3 jurisdictions, do they track location? The one that the UK is about to roll out doesn't actually. It just works on Bluetooth identification keys, not on GPS location, which is one good thing.
The same actually in Poland. However, we have at least 2 tracing apps already deployed in Poland. One is Bluetooth, and the data controller is Chief Sanitary Inspector, and it is a social distancing application, let's say. And the other is home quarantine, which is a mandatory for those who are under the mandatory quarantine, those who returned from the abroad, for example. And then certainly there is a location, there is I would assume face recognition, because basically it works that way, that I shoot a selfie, and then whenever I am requested by the system to repeat it, I am making selfie again, and the selfie is connected with the location, because earlier I need to define where I spent my quarantine, whether I'm at home or I'm in a spa and resort, whatever. Therefore, such a match is being conducted. And on top of that, of course, the telecoms may be requested by the Ministry of Digitalization to get location data from mobile phones. Therefore, pretty extended mosaic. And the bottom line, as Clarissa said and as Fred said, I think the bottom line is basically trust and legal safeguards, which may be ineffective. And trust, I'm afraid we are living in times of trust deficit, I would say. Therefore, and this is one of the problems we are meeting today, because basically that's why maybe fighting against COVID-19 using technology is nice. It is something that the European Data Protection Supervisor and board are stressing. That's right. But basically, I think the bottom line, and we are afraid, and our stress comes from the fact that basically there is lack of trust, not sufficient trust, and we don't know how the data will be used. We don't know what the scope of data in the end will be collected and for how long.
Right.
I'm sorry, and that's one concern that has been very specifically addressed in the California Consumer Privacy Act, which has a bit of a different twist on the use of data as opposed to the GDPR. One of the tenets of the California Consumer Privacy Act is that the person should have control over their data in terms of whether or not that's sold, and has the right to have knowledge about what the data is used for, so that a company that is using data, and there's a lot of apps that you can have on your phone that do just not necessarily contract tracing, but location tracing, they have to notify you if you ask the company to, they have to notify you how they're using that data, and they have to notify you if you ask if they've sold that data and to whom they've sold it to. So there are protections that are available, but it really is more, in my view, an affirmative duty on the consumer to restrict the use of their data and to restrict the sale of their data for contact location or tracking purposes.
We have a similar thing. The individuals have rights to access the data and to find out about it, but there's also a positive obligation on the data controller to be transparent and to tell people exactly what they're collecting and why, and who they're sharing it with. Which is why privacy policies that we draft now are enormously long. But it does mean that we're, you know, in this country, the government are producing policies for their tracking apps, and so we do know things like how long they intend to keep the data and who it's supposed to be shared with. But there's always, you know, the possibility that things don't go quite according to the original plan. And when things are revealed, then it causes some kind of alarm. We've just heard that the track and trace system that's just been implemented here, where they phone you up and ask you who you come into contact with, that is going to retain data for 20 years. And I'm not clear why they need that for 20 years. Hopefully we would have a vaccine by then.
So that leads us to a question that was brought by Gustavo Godinho. And he says that, hello, he says, great listening to you. Here's my question. What is your opinion about contact tracing technologies? Can it be used or implemented in a good way to help during this COVID crisis? And what are your concerns regarding privacy data protection laws versus contact tracing technologies? We've been talking about this, and what I think is an important issue to bring with you is that in Asian countries, like in Taiwan, I don't know if you heard about it, but in Taiwan, people would get calls from the police, and if they didn't return the call, or I'm sorry, if they didn't get the call, they would have the police knocking on their door in 15 minutes or so. So the tracing there was like that, was strict and very individualized, right? Even with no consent or anything like that. So do you think in countries like Taiwan, China, Japan, Singapore, they had a positive effect out of this high monitoring and contact tracing. So they had a positive effect out of that. So will this be a model? Will this be a model for us, for the other part of the world where we are not, our culture does not include viewing that as a more common thing to be largely monitored? What do you think? Please, Bartos.
If I may, yeah, add on referring to Gustavo's question. I came across Oxford Big Data Institute research, and basically, according to their assessments, it is necessary that approximately 80% of mobile phone users use this voluntary application, because otherwise it brings no effect. Each health organization says it is 65–70%. Anyway, it is vast majority of mobile phones users. Therefore, maybe also referring to your, Clarissa, to your question, whether it's gonna work. In case of quarantine, it worked in Poland, I must say. The system was quite similar, even without the application. Basically, you never knew when the police would come, knocking your door, asking, are you in, how are you doing, you are okay. And it worked that way. Therefore, I would say we were relatively disciplined society from that perspective. Do we like being monitored, and how many people will download this application? I'm not very enthusiastic about statistics. I would say it will never get to and as long as it is on a volunteer basis, we will not get in Eastern Europe up to 80% of users.
Apparently in Singapore, even in Singapore, which is a very sort of conformist society compared to some of Western societies, they only got like 20% of people downloading the app. So yeah, 80% of smartphone users, which I think I read the same article. It said that would mean 56% of the population of the UK would need to download it.
Yeah, and that in and I think I read a similar article, but I was reading another story where in Wuhan, where they're getting people back to sort of regular society, there's a requirement that on your phone you have an app where if you go to a restaurant, you're required to register for getting into the restaurant, which lets the government and the officials know everywhere that you've been. And of course, there in Wuhan, that is a mandatory app, so there's no sort of voluntary use of it. The restaurants are required to have you scan your app before you enter the restaurant. There's nothing like that that will occur in the United States. But I would have the concern that if there is sort of broad contact tracing that takes hold in the United States, even though it wouldn't be a requirement, it may be a smart thing for a restaurant to require of its patrons before they enter, because the United States is a very litigious society. So I could certainly see where if somebody were to contract the virus at a restaurant and that could be traced, the restaurant could be subject to a lawsuit, and that could prompt restaurants or other businesses to want to have their patrons do it. So I don't think from the consumer side they would necessarily want to have that app, but from businesses facing potential liability, there's an incentive to ask that their patrons do it before they enter.
And would the restaurant be acting legally by asking the customers to do that, or would the restaurant be discriminating or in some way breaking the law and asking them to do it?
That's an excellent question. I mean, there's been issues even where there's not a requirement that people wear a mask prior to entering a business. Businesses can require that, and people have pushed back against that. We've not seen lawsuits on that yet, but I can imagine there would be. So I could certainly see where there would be a potential for a lawsuit from the other side. You're not letting me in and you're discriminating against me somehow. So it is fraught from both ends.
If it is a private place like a restaurant, I can see that the owner has the right also to look for the health of the place and for the other clients as well. As in Brazil, we have that in our future law, which will come into effect hopefully in August. But it brings it's very similar to the Gdpr and brings 4 additional legal bases, and one of them is the use for health safety in many different topics and everything. But when we think about, and that's a very good question also that Fred has brought up, the thing about the discrimination, when we think about another topic here that I thought is the passport, the immunity passport that Estonia is already testing, I think, and other countries will probably use. It brings discrimination, I think so, because when you say that someone has to prove that they have already got and that they are immune to a virus that hasn't even been spread at all through what, 10% of the population of each country. So will you have to be one of the 10% to be able to travel to other countries? The WHO, the World Health Organization, hasn't yet hasn't said anything for sure about it. They didn't condemn. They didn't say anything against or confirming the possibility of using it. But the American Civil Liberties Union, that Fred probably know a lot about, they said that it has a potential to harm public health and to incentivize economically vulnerable people to risk their health by contracting COVID in order to be immune.
Yeah.
They said that, and they said that it also increases racial and economic disparities. I would like to hear about it. What do you think about the passport?
Well, I think at the moment they don't know even if you are immune, if you've had it before, like they don't know how long the antibodies last and whether that protects you. So it seems pretty pointless until that science is nailed down.
Yeah. No, I share Robert's view on that. Basically, we are many steps behind making that kind of decision, and then of course we have dilemmas. Clarissa absolutely properly raised, and I think it also goes to the balancing test that is visible on the screen, balancing different values, and it is data protection is more and more about balancing. We are now kind of back to the war against terrorism situation, but now this is not terrorism, now this is the virus. And again, the balancing, how much I can accept in terms of trade-off of my privacy versus my safety in whatever terms, physical, healthy, whatever. And I think this is the biggest philosophical question we will challenge, generally speaking, in terms of data protection, but not only in terms of data protection, but in terms of our civilization even. You know, there are those theories that actually it was all created by the Chinese or by Americans or by whoever. So the conspiracy theorists. I'm not referring to that, but I think one day indeed we will need to basically somehow challenge those opinions and to decide what kind of trade-offs and for how long we are ready to accept. As Robert said, 20 years, pretty long distance, I would say. Similar Polish applications, they are quite relatively long-running applications, I would say, in terms of deadlines, in terms of deleting data. It is not entirely clear for me when I read the bylaws of those applications for how long the data, if any data is stored, how long it's going to be stored. So I think this is a fundamental question: how to balance, how much we can accept.
And I think the balancing is one reason why there is different responses from different regulators across Europe. I'll just show you, if the slides can advance, some of those responses we had from our European colleagues before we ran out of time. So we asked a few people about contact tracing apps. You'll see there's a mix between those using a centralized model, like the app that France launched a couple of days ago, and the UK one as well, where the government actually gets all that data, and the decentralized model, which is the one that Apple and Google are promoting, where the processing is just done on users' phones. Decentralized is obviously, you know, if you're balancing risk and benefit, decentralized is lower risk, but it's not as much benefit because the centralized system lets you do all kinds of analysis on trends and things. So that balancing that Bartosz mentioned is very important, and different governments and different regulators are taking different views. The same goes for the question of whether or not you can do temperature screening of employees and visitors. I tried to advance the slide, but it hasn't worked. Oh, there we go. So in some countries, it's fine. In some countries, you absolutely mustn't do it. And this is all just within Europe, all covered by the same GDPR. But it's because of the balancing and because of the overlap with national law that we mentioned before.
If I can add, that's become a fairly recent issue here in California and in the United States. The United States, you know, one of the strongest privacy acts is Hipaa, and that's the Health Information Privacy Protection Act.
Yeah.
Under Hipaa, the regulators have provided guidance that as an employer, you can take a temperature, and you can also ask an employee questions prior to them entering your facility regarding, you know, any symptoms that they may have. So you can do that. But what you can't do is tell other employees, what that information is. And if somebody tests positive for COVID, certainly you absolutely can't tell the other employees that employee tested positive. However, you can tell employees that you may have been exposed to COVID. So that's sort of the balancing that they've struck here.
Interesting. The UK regulator, the Information Commissioner Officer, the Information Commissioner's Office, has just put out some guidance on it recently, and they said you can tell other employees, but you should bear in mind data minimization. That you should, if you don't have to tell them the name of the person, then don't. Like, do it on a need to know basis. But it's not forbidden as such, but in some countries it is. They're saying that you mustn't, absolutely cannot tell people. What's the situation in Poland, Bartosz? Are you allowed to?
It's quite similar. I think Data Protection Authority presented an opinion saying that GDPR does not forbid those temperature readings and measurements. However, you must comply with other regulations. So pragmatically, quite a few employers reach out to sanitary inspectors asking for permission or even asking for being instructed to conduct those measurements in order to have clear legal grounds for doing that. In terms of informing your staff if one of the employees is infected, it's very similar to the UK practice and ICO standpoint. And I think actually to a great extent, we rely on your authority's opinion in that respect.
Interesting. Well, we're we're almost finishing the time here, but I think we could hear from you about the temperature. You said that, Fred, I understood that. So in the US, you can do that. You cannot tell the one that was that has a disease, right, to the others.
Correct. Yeah, I'm sorry, just to add to that, from a pragmatic perspective, if you have a set of office workers and one of them is there one day and they're gone the next, and then you tell the surrounding employees, well, I can't tell you who the person is, but you may have been exposed to COVID, practically speaking, they probably can figure it out by deduction. So so from that regard, there's no there's a little bit of lack of teeth to that, but however, the overall thing is, you can't affirmatively state who the person is.
Right.
Yeah. Do you think that the GDPR was relatively not new, but the regulation said one thing, and now the pandemic brings another issue, and another thing is necessary for us to do, which is to overcome some of the regulation articles to allow the temperature monitoring, to allow the contact tracing, to everything. So do you think that the regulation will continue to be interpreted as it is, Robert?
The regulators have different views on it, but I think, yeah, the European Data Protection Board, which is the sort of club for regulators, they basically said that the GDPR doesn't stop you doing anything that you want to do. It gives you the tools. It just means that you should adopt the least intrusive solution where you can, and you must be accountable for it and work out what your legal basis is and all that stuff. So they're not saying that changes need to be made, but there is a lot of room for interpretation on a number of the provisions.
Mm-hmm. Maybe rephrasing what Clarissa's question, I wouldn't say COVID-19 brought the end of GDPR. I would even dare say to the contrary. It is GDPR still seems to be a nice bottom line which lawmakers cannot cross. So I would say I think my position changed over the last couple of years. I've been dealing with data protection for more than 20 years now. And basically, I was much more business oriented, saying, oh, yes, we can do this, we can do that. Now, all of a sudden, I started looking at GDPR as really safeguards of our civil rights, considering how much technology can do with our data or against our data. And so I don't know, Robert, whether you agree, but to some extent, indeed, I changed the opinion, and I would say, thanks God we have GDPR.
Yeah, it does give some useful protections, I think, to stop overreaching. Yeah. Although there has been some criticism that the regulators have not been perhaps enforcing it as toughly as they could be, but it's still early days.
No, I definitely appreciate the GDPR and the CCPA and greater privacy protections, and my switch flipped when I realized, and I've never gone on Facebook, but once I realized that persons who use Facebooks are not the consumers, they're the product.
Yeah.
So when you're the product of something, I think you have a very different perspective.
The Cambridge Analytica scandal was a watershed moment, I think, where people realized that these rules are there for a reason.
Many people say that we've seen the GDPR has turned 2 years old, and a lot of people say that there's no enforcement, no high fees. Is there really a problem? Is that why the GDPR was created, to put high penalties? Is that really a problem?
Right.
That's my final question for you.
I suppose it's only a problem if people think that it doesn't have teeth and they start ignoring it. But yeah, I think we will see those fines. Yeah, we saw Google got fined, was it like 40 million pounds, 50 million euros, something, by the French regulator Yield last year, and the British regulator was going to fine British Airways and Marriott 183 million was one, and nearly 100 million was the other. And they haven't issued the penalty notice. They haven't made the fine final, and that may not happen now, given the state of the travel industry. But I think you know, the threat is good. It makes people raise these issues to the board level rather than it being just some compliance person having to tick a box. I think they're very important.
Robert, if I can, I would quote you, because you had this article or interview on Compliance Week. I just had it in front of me. And you are saying here, and I agree, the factor that is most likely to delay big fines is simply that the virus will make it difficult for the supervisory authorities to complete their investigations. And indeed, and my reaction to this sentence, which I fully support, is, however, one day the authorities will go out and then God save us. Yeah.
Very good. Very good. And Fred, the last one, the very last one for Fred. What do you think about the federal regulation? Will it come up or not? The US one. Will we have a GDP in the US in the next 1 year or so?
Our political system right now is under such stress on issues related to COVID, issues related to civil rights protection, related to sort of an unstable executive branch. I can't see anything that I think could pass before this November. There's been some legislation passed around, but it hasn't gotten very serious consideration. I would say that we are absolutely going to have some sort of regulation once there's lawsuits that are filed under the CCPA by private parties that result in large awards. I think you'll see more of a move toward federal legislation.
Hopefully. Thank you. Thank you, Bartos, Robert, Fred. Thanks a lot for being here. Thanks, everyone, all the participants, everyone who were here. We'll hopefully have another one soon. Thank you, Meritas. Thanks, Jamili.
Thank you.
Thank you. Thank you very much. I just want to mention just a couple of things really quick. First of all, I want to apologize if there was any feedback coming from my line and any distraction that may have caused. And second of all, I want to thank Clarissa, Robert, Bartosz, Fred. Thank you for joining us today and for speaking with us. That was very informative and it was a really great presentation. Before we sign off, I wanted to remind each of you that in the next few days, I will distribute a copy of this presentation, a recording of the webinar, as well as each of the presenters' contact details. Please do not hesitate to reach out to them directly if you have any further questions. You are also welcome to share this recording with anybody you think that might find it of interest. With that, thank you again for taking the time to join us today, and I hope everyone has a really great day. Bye.
Bye, Crystal. Thank you.